The Supreme Court is gearing up for oral arguments on two blockbuster controversies.
Today, the Supreme Court heard the latest case that's testing the limits of the constitutional right to carry a gun in America.
The next massive Second Amendment ruling is already sitting on the Supreme Court's docket, and most gun owners have no idea about what is about to happen.
The Supreme Court heard arguments today in a case that could reshape gun rights in America.
So the Supreme Court recently granted review to the next big Second Amendment case, and once again, it deals with state concealed carry restrictions.
One thing that's really important to remember is that the Supreme Court never really weighed in on the Second Amendment or Second Amendment rights.
The Supreme Court just did something behind closed doors that could completely rewrite the rules on gun permits for every single American, and almost nobody is talking about it. This is not some slow-moving legal debate. This was an emergency intervention, the kind the court almost never grants, and what it signals for your Second Amendment rights is something you absolutely need to understand right now. So here is what happened and why it matters so much more than the headlines are letting on. The Supreme Court does not hit the emergency button lightly. Out of the thousands upon thousands of applications that land on their desks every single year, they grant emergency relief in only a handful of cases. We are talking about a fraction so small it barely registers statistically. So when the highest court in the land decides that something cannot wait, that it needs to act right now, rather than letting a case wind through the normal multi-year process, that tells you the situation has reached a critical point, and this situation absolutely had. After the Supreme Court handed down its landmark Bruin decision back in 2022, the legal landscape for gun permits was supposed to change. That ruling established a clear constitutional standard. If a state wants to restrict your right to carry a firearm, it has to show that the restriction is consistent with the historical tradition of firearm regulation in this country. Not a general vibe, not a loose resemblance, an actual historical match. That was the new rule, and every state in the country was expected to follow it. Some states complied, they adjusted their laws, updated their permit systems, and moved forward in good faith. But other states, and this is where things get really interesting, decided to play a very different game. Instead of genuinely complying with Bruin, they passed new laws that looked different on the surface but accomplished the exact same goal they had before, making it functionally impossible for ordinary law-abiding citizens to actually use their carry permits in daily life. The numbers on this are staggering. Within just 18 months of the Bruin decision, at least 11 states pushed through a combined total of more than 30 new gun restriction laws. 30 new laws in a year and a half, and these were not laws designed to comply with the Supreme Court's ruling. They were laws specifically engineered to get around it, to find loopholes, to technically follow the letter of the decision while completely gutting its spirit. One state went so far with its restrictions that permit holders filed an emergency application directly with the Supreme Court, arguing that every single day this law remained in effect was another day their constitutional rights were being actively violated. Not theoretically violated, not potentially violated, actually violated in real time with real consequences for real people. And the court agreed to step in. Now, before we get into the legal arguments and the constitutional questions at the center of this case, there is something most Americans genuinely do not understand about how gun permits work in this country, and it is going to change how you think about this entire issue. Most people assume that a gun permit means roughly the same thing no matter where you are. You get your permit, you pass your background check, you do your training, and you are good to go. That assumption is completely and totally wrong. The difference between what a gun permit means in one state versus another is so dramatic that it might as well be a different country. Right now, more than 29 states operate under what is called constitutional carry. No permit required. The state trusts you to exercise your right without asking permission first. In most of the remaining states, you can get a permit if you meet clear, objective criteria. Pass the background check, complete a safety course, pay the fee, done. But then there are the states where the government has historically reserved the power to simply say no, for essentially any reason, even if you check every single box on the application. There are currently over 22 million concealed carry permit holders in the United States. 22 million people who went through the process, cleared every hurdle, and obtained their legal permit. And yet in states like California, New York, and New Jersey, many of those same people find that their permit is practically worthless the moment they walk out their front door, because nearly every public space, business, park, and gathering place has been reclassified as a restricted zone under these new post-Bruin laws. That is the reality on the ground, and that is exactly the reality that produced this emergency case. So what were the actual legal arguments presented before the court? This is where it gets really critical, because when lawyers argue before the Supreme Court, they are not just fighting for one case. Every word they say becomes part of a legal record that judges across the entire country will reference for decades. The challengers kept their argument clean and direct. The Second Amendment protects the right to carry a firearm. The Supreme Court confirmed that in Bruin. Once that is established, the burden shifts to the government. The government has to demonstrate that its restriction matches something that genuinely existed in American history around the time the Constitution was adopted. Not something vaguely similar, not something that shares a passing resemblance, a real, substantive historical parallel. And the challengers argued that the government simply cannot produce one, because this kind of sweeping location-based permit restriction did not exist in early America. And here is a detail that does not get nearly enough attention. Several of the historical laws that restrictive states most frequently point to as justification were originally enacted specifically to disarm Black Americans after the Civil War. Multiple legal organizations have documented this extensively, using laws rooted in racial disarmament as the constitutional foundation for modern gun restrictions is not just legally questionable, it is historically indefensible, and the court is going to have to grapple with that. Now, all of this leads to 4 constitutional questions sitting at the absolute center of this case, and how the Supreme Court answers these 4 questions will not just decide this one dispute, it will set the rules for more than 150 active Second Amendment cases currently working their way through federal courts right now. Question 1. How close does a historical law have to be to serve as a valid comparison for a modern restriction? The government wants a loose standard where rough similarity is good enough. The challengers want a strict standard where the match has to be genuine and specific. This matters enormously because a loose standard gives states nearly unlimited room to dig up some obscure old statute and use it to justify almost anything. Question 2. Can a law that appears neutral on paper still be unconstitutional because of what it actually does in practice? A law that technically allows you to carry but then bans carry in 70% of accessible public spaces does not meaningfully protect your right. The court has to decide whether it will evaluate these laws based on their real-world impact, not just their carefully crafted language. Question 3. Does the Bruin standard apply to all types of permit restrictions or only to outright bans? Some lower courts have been trying to argue that Bruin only prohibits total prohibitions and that heavy regulations short of a complete ban are still perfectly acceptable. If that interpretation survives, it would hollow out the practical meaning of Bruin entirely. Question 4. What role does public safety play under the Bruin framework? Bruin made clear that a public safety argument standing alone is not sufficient. Historical grounding is required. But some courts keep allowing public safety justifications to creep back in through side doors and procedural workarounds. The Supreme Court needs to seal those openings shut. Every single one of those 150 plus active cases is waiting on these answers. The stakes could not be higher. So what has the immediate impact been? Emergency decisions from the Supreme Court move fast. Their effects are felt within hours, sometimes sooner. The most direct consequence of this particular emergency action is that the challenged law has been paused. In the jurisdiction where this restriction was being enforced, permit holders may have had their practical carry rights restored overnight. People who went to sleep unable to meaningfully use their permit in most public spaces potentially woke up in a fundamentally different legal environment. And this does not stay contained. Lower court judges actively watch what the Supreme Court does, even in emergency posture. Citations to Supreme Court emergency orders in lower court Second Amendment rulings have increased by more than 40% in the 2 years since Bruin. Judges are paying attention, they are adjusting. The ripple effects are already spreading. The reactions from both sides have been exactly what you would expect, and also more revealing than most people realize. Gun rights organizations are treating this as validation of the legal strategy they have been building since Bruin. They are calling it a critical step toward ensuring the promise of that decision is actually kept. But more importantly, they are already identifying the next wave of cases to file, using this emergency order as a new foundation to build on. On the other side, gun control advocacy groups moved immediately into damage control. Organizations with combined annual budgets exceeding $100 million issued statements calling the decision dangerous and urging state legislators to find new approaches, which, if you read between the lines, means they are already drafting the next version of the law. The cycle continues. Here is something worth noting, though. Gun control groups outspent gun rights groups in federal lobbying and campaign contributions by more than 2-to-1 in the 2022 election cycle. And yet the legal victories in the courts have been moving consistently in the pro-Second Amendment direction since Bruin. Money wins elections and it wins in legislatures, but in a courtroom, the Constitution still carries weight. For current and future permit holders, this decision changes the practical landscape in ways that are both immediate and long-term. If you hold a permit in a state directly affected by this ruling, the restrictive law that was limiting where you could carry may now be paused, potentially restoring your ability to carry in places that were previously off limits. If you are in a state not directly named in this case, attorneys are already analyzing whether the same constitutional arguments apply to your state's laws. In many cases, they do. And here's a data point that matters in this conversation. Concealed carry permit holders are one of the most law-abiding demographics in the entire country. In Texas, a 2021 analysis found that permit holders were convicted of crimes at a rate more than 18 times lower than the general population. The argument that expanding carry rights increases crime is simply not supported by the evidence. Looking ahead, the most significant potential policy shift on the horizon is what legal scholars are calling a de facto national floor for carry rights, a minimum standard below which no state can go when it comes to issuing permits and allowing people to actually use them. If the Supreme Court writes a broad opinion that explicitly prohibits the functional nullification strategy these restrictive states have been running, it would force every state in the country to maintain a genuinely usable permit system. There is also growing momentum behind national reciprocity. Right now, qualified active and retired law enforcement officers can carry concealed firearms across state lines under federal law. Ordinary law-abiding permit holders cannot. A strong Supreme Court ruling on carry rights could accelerate legislative efforts to create a system where a permit issued in one state is recognized in all 50, the same way a driver's license works. Public opinion is shifting too. A 2023 Gallup poll found that 56% of Americans support concealed carry rights for law-abiding citizens, and that number has been climbing steadily for over a decade. When the legal momentum in the courts and shifting public opinion are moving in the same direction at the same time, that convergence is rare. And it is exactly the kind of environment where lasting generational policy change actually takes root. But none of this is guaranteed. An emergency decision is the beginning of a legal process, not the end. The next steps involve continued litigation, additional rounds of legal briefs, more oral arguments, and eventually a full merits decision, a complete written opinion that sets binding legal precedent for the entire country. That full opinion is the finish line. Everything happening right now is the race to get there. If this case lands on the current terms docket, a final opinion could arrive as early as spring. If it carries over, we might be looking at mid-2026. And every single month between now and that ruling is a month during which states will be maneuvering, both legally and legislatively, to position themselves as favorably as possible. Every word written by every justice in this case matters, not just the majority opinion. Concurring opinions in major constitutional cases get cited in subsequent lower court rulings at a rate nearly equal to the majority opinion itself. Lawyers on both sides will be dissecting every sentence, every footnote, every carefully chosen phrase, looking for any opening they can exploit. This emergency decision cracked the door open. The final ruling could blow it off the hinges entirely. What happens next will shape gun rights in America for a generation, and the developments are going to come fast. That's it for today, folks. See you in the next video.